perhaps on our side this morning. Uh, and we're ready to listen to y'all on whatever your feedback is from the other day. Working on a number of other pieces of the remaining moving parts. So I'll turn it over to y'all.
Do you want to have this discussion on the G file?
That'd be fine. I think that's as good a place as any to start.
Well, our position is fairly simple. We're going to propose that we delete it from the contract since there's no certainty as the city can't live up to the deal that they made. And I'm not pointing the finger at them. It was a court ruling, and then that's uncertain. So the deal that we agreed to at the table, you can't live up to. So we'll take it out, and then everyone will live with whatever the court holds. It'll be a law. The court has already held what it means in Austin, Texas, and we'll live with that.
Tell you why we disagree with that approach, and try to encourage y'all to help us sort through the difficulty that we find ourselves in the course of this bargaining. And I'm assuming, let me just clarify first of all, when you say we can't live up to the deal that we made, I'm assuming that you are talking about the fact that our TA would have made the G file, would have eliminated it on a prospective basis from the date of the contract.
That's correct.
Okay. So we recognize that perspective. And I think there are a number of things that we need to confront and things that the public need to understand as they look at the way this works and what's currently going on. First of all, there's been a court ruling. Court rulings by trial courts are not final until a certain period of time goes by, until issues about appeals are resolved. As you well know, counsel for the APA had pending proceedings in the Supreme Court over the issue of APA standing on this issue. That's been rebriefed with a supplemental brief and a request to the Supreme Court for a stay. The ruling in the trial court is not final. And so nobody knows what the ultimate answer will be. That is the very reason that we came back and gave you our first cut at conditional language on having our agreed TA apply if we find ourselves back in the same position we were in when we negotiated it. And that's the way I wanted to try to frame this so that you can understand it. I think there's some misinformation out there in the community. We have never negotiated to keep part of the G file secret. Some people perhaps seem to feel like that's the case. We negotiated with your association and y'all came to the table and were forthcoming. We appreciated the approach that you brought to the table. You agreed that you would accomplish what Prop A required you to do. And we believe that the TA that we signed did so. And frankly, I'm proud of both teams for being willing to do that. It was the legal conclusion of the City of Austin Legal Department that Prop A could only be accomplished by a prospective contractual preemption of this part of Chapter 143. So now we have a not final court decision that leaves things back up in the air and uncertain, just like they were when we reached our handshake on that as a potential part of this labor agreement. We think the proper constructive thing to do is to allow that court decision, if it does in fact take place and become final. That's what our language has attempted to capture. That decision or the decision of some other court, and that's why we refer to a binding final decision from some court. Because if that train has already left the station and it arrives at wherever it is going and it's final and it's over with and it's the rule, then we're both bound by it. If that doesn't happen, and if it turns out that the G file is not public to everybody, and it's not public under all circumstances, and it's not public to the beginning of time, if the issue gets resolved about whether or not it is public from the effective date of Prop A, or that it can only be public from the preemption date, then we have the answer in the context that we had already negotiated. I don't know any way to say it any simpler than that, because it's not a simple black and white answer, because there's multiple. We're not trying to have our cake and eat it too. We're trying to have certainty one way or the other as we go forward. If the judicial outcome after the Supreme Court weighs in on this is that Prop A can't be changed by the voters, once again, that's an issue that hasn't been finally determined, and it's not a decision that's over and done with. Well, that's the only reason we find ourselves where we are. And I appreciate your comment that you're not pointing the finger at us about whether or not we can live up to the deal that we made. We've all known as we sat here and bargained this, that we had this case out there. The issue of APA standing was addressed. Trial court denied party participation by the association. Y'all took that to the Supreme Court. In the meantime, after a considerable delay, we've had this trial court ruling, and now we don't know what's going to happen in the future. So that's our position. We think that we have bargained responsibly to come up with an answer that should be the 5-year solution to this problem if the court should rule that Prop A is not self-effectuating, or if it should rule that Prop A is self-effectuating, but is not effective with respect to materials in a G file that happened 15 years ago before there was ever a Prop A. So that's what we're trying to accomplish. I appreciate you listening to the explanation. We are informed by the city attorney that conditional language that resolves and satisfies Prop A, even in the event that the final court decision says otherwise, is a requirement for her certification of the council's ability to pass the labor agreement. So that's our struggle. What other issues do we need to talk about?
Well, is the city today going to release all of the G files with no time limit, no perspective either way? Because we don't have a contract. We may have one in the future. It could be months from now. So what is the city doing today? So if you're going to release them all, then why are we bargaining over something you've already made a decision on? So I hear you, but you can't live up to what's in the contract. So I'm not quite sure this language you put in there, since we sign it and it says it's prospective from the date of the agreement, but you can't do that. So why would you sign it knowing you can't do it? And then ask us to wait. We determine courts, legislature, all these other entities are going to make rulings that could drag on for the next couple of years. But you'll just keep this down here in case you end up on the wrong side of it. You'll still have this. You can't promise anything. And we're okay with that. We're not arguing against it. The court ruled. People have a right to appeal. I suspect there'll be more legal cases as people find out the materials in their file that are 15, 20 years old that were proven not to be valid. It places them in an unfavorable light, damages their reputation and career. And the department had investigated and cleared that that's going to be released to people who just want to look. Now that's fine, because if we don't put it in the contract, 143.89G will apply, and you'll have a court ruling saying in Austin, this is what it means. And we're okay, we'll live with that. But I can't see putting it in here, because you're saying put it in here, but We just want to hold it over here because the city attorney won't sign it if we have prospective language. Then why are we bargaining prospective language if your side can't sign it? And say, well, let's just wait and see what happens. We don't need language to wait and see what happens. Let's just wait and see what happens and we move on.
Well, but what you're hiding about wait and see what happens is if we sign the labor agreement without this in there, court rules, the Supreme Court sends the case back and APA gets party status
Yeah.
and this issue gets.
Yeah.
And it turns out that the G file is not prospectively
Okay.
released and not available, then we get to sit here and wait for 5 years to bargain this again.
Well, you should have bargained it this time. And you didn't.
We did.
You did. And now you're taking it back.
Well,
No,
we're not
no.
taking it back. The
You're
court
ta-
took it back.
Okay, but that's fine. We should take it out.
We
of the
didn't do
contract.
that. You know, we didn't do it.
Take it out of the contract.
And
And
live
let
without
the
it for
court-
5 years.
Well, okay, it could be 5 years in the courthouse. Your language is no time limit. It doesn't say, well, if we don't figure it out in the next 6 months, we'll go back with perspective. Take it out. We didn't sue. The city chose to settle this case and not fighting it out to determine the city is going to accept.
I don't know why you're saying.
Well, the mayor
city-
said it in a public statement. We're not going to appeal.
All right, I'm sorry. The city.
That was
didn't
in the
choose to
mayor's
settle the
newsletter.
case. The city opposed this out.
Yes, and now
And the judge disagreed.
that's correct.
Okay,
And there are
let's
still
put the record
appellate,
straight
there's
about what
appellate,
happened.
there are appellate routes. They chose not to. That's fine. We're not arguing over there. We'll live in that world because we got lawyers, they got lawyers, we got legislators, they got legislators. Let it settle. It has nothing to do with this contract.
And just so it's clear, and I'm not trying to fight with you at all, Ron, you know, the APA thinks it's the wrong decision and has asked the Supreme Court to stay it and not allow the release of those old G files.
That's correct.
Okay.
And we've never hidden that.
And all we're saying is we want to know that answer before we decide what the contract
Well-
solution is, if.
No, you want to keep what you bargained and we bargained with you in good faith. Because the city won't sign it with this language in there unless it just, we're setting it aside. Because someday, if we lose, we want to keep this little piece. Well, you may get it all. You may get none. Is the city going to release the files, G files, to the people who've requested it, regardless of when the officer worked here to be dead by now? That's the question.
It's a good rhetorical question.
Well,
If I could jump in,
absolutely.
I don't think we're arguing the same thing. What we're saying is that the city council cannot pass the contract if that question is left open without this language. Because the city's attorney is saying, if it's left open, then it's not compliant with Prop A. We're not arguing the legalities of the case or whether this should happen or that should happen. We're saying the city attorney, and I can't disagree with her. If we leave it open to where a court can say, you know what, the G file has to be bargained for. That's the ultimate answer here. If that's the ultimate answer of a court, then we are not compliant with Prop A. And for that reason, the city attorney can't certify it.
Well, with the
It's
city,
plain and simple.
Sarah, what you're saying is, we don't know what's going to happen. We're throwing in the towel. We're going to let it happen. I'm not going to sign it if you do this. I'm not going to sign it if you do that. We should take it out and let's all live over there with the law. So what you're saying is maybe it'll be negotiable. What you just said, maybe it'll be negotiable. If it's negotiable, then we'll bargain over it. But this is ridiculous to say, I can't live with this, but I'm just going to keep it in case I don't get as good a deal later.
Because this happened now,
Yes,
because the court chose to rule now,
yes,
we're not in the position that we solved this problem in the contract, living with the world we were presented with. And you are saying if it turns out that we have to bargain it, we'll bargain it.
Sure.
But you're really saying we'll bargain it when this 5-year contract is over.
maybe. But I'm just struggling. A group of people went out and took it out of our hands, passed an ordinance to get ahead of us at bargain. That's exactly what they did. We're going to run out ahead, block the city and the union from agreeing on these overtime. And they got it, and they passed it. And now everybody's got to live with that result, including us. So We didn't start this. We were prepared to bargain over. We have bargained over. And had we signed this deal already, this whole clause could have been thrown out by the judge in the court. So I don't get it. So if that's your position, I'm not sure where we're going from here because we've agreed to live with the law. And you can't live up to the deal you put in here unless sometimes maybe later some court says you can't.
It is not compliant with Prop A, and the city attorney will not certify it under the terms that you're suggesting. It's that simple.
So I also want to make it clear that we believe that your interests in this issue can be protected by conditional language. And I'm asking that you revisit that option. I'm not looking for we have our cake and eat it too scenario. We're looking for, if we find ourselves back in the same position we were in when we made this TA on the G file, if that is where the courts actually end up, I don't know where they end up there or not, nor do you. If they end up in that position to where we have uncertainty about this, we don't know the answer about whether or not the G file is open as a result of the passage of Prop A and whether it is retroactive, prospective from some date or not. When we find ourselves in that same position, our language would then be effective. Otherwise, that language is not effective and the court decision controls us both like it otherwise would. We think that's the best solution and the city attorney will certify that as compliant.
You know my opinion about this constant threat. She will sign it, she won't sign it. In the end, she can make up anything she wants. And if she decides, I'm not going to sign it because I want to keep something I can't live up to. In fact, I won't sign it if it had that language. But if you're just setting it aside, because what if I don't get as good a deal? And you may not. We got a legislative session starting in a few months. So this thing could drag out 5 or 10 years. Well, this is one piece, but every piece of this puzzle, we have bargained over where we saw that there was a conflict with Prop A. And we bargained this in good faith. Okay. Now the law changed. Okay, we'll live with the law. I don't see any reason that we give you something which you cannot live up to because you just want to keep it, but you can't keep it.
Well, I've explained the best way I know how to explain why I think that protects your it is not a threat about the city attorney's certification or not. I can certainly see from y'all's standpoint, that's what it looks like. It is an ordinance provision, a provision of the law adopted by the voters in our democracy that the city doesn't have the power to sign a contract without that certification. It is a precondition to us making a deal. I'm only bringing it up because it's a precondition to us making a deal, not for a threat.
You got a court said it doesn't apply, but you don't know what that is.
So I would just ask you, do you believe that it would be compliant with Prop A with the language you were suggesting?
My language is no language.
I understand that.
So yes, it would be compliant because this contract did not address it. The contract is superseded by the court ruling anyway. We don't have a contract. So if we sign one tomorrow without it in there, the city attorney, that issue was removed by the court from our power to bargain over. The court said, this is the rule on this. This is the rule. And we're okay. Well, any contract in which the court comes in and picks some at you and says, well, you can't pay unlimited sick leave. Well, we have a section here that allows us to take out parts of what the court may rule. So the court's not going to rule on this prospective language. On our prospective language, the city attorney has to follow whatever the law says. Our contract doesn't supersede the court's ruling. So where we had a conflict, we agreed to it. We superseded 143.089G. We have no power to overrule the court's opinion on what that means. So you're asking us that we have to supersede it. We can't supersede it. It is the law as set out by the court for the city of Austin. And that's the law.
But it's not the law finally. It is a preliminary interlocutory court decision.
Yes, yes.
Okay. And it's that twilight zone that causes the problem.
Are you
If it
going,
was a final decision, like you said, we wouldn't be in the twilight.
there will be a final decision.
So, and moreover, the language that we recommended and that we're willing to talk about specifically stated that it only applies to the extent that they're not contradictory to such future ruling. We're not trying to overrule any future ruling. We're saying what's sitting there is only applicable to the extent it's not contradictory to any future.
Or is the city going to release under the open records request you received? Well, you ought to know, you talked to the city attorney. Is the city attorney going to release these files now under the request for open record? Are they going to deny it pending the outcome of this case?
So I will tell you, I do not speak for the legal department. I do know that there is a posted executive session regarding this ruling tomorrow.
Okay,
So I don't believe that decision has been made.
okay. So
So-
if the city
so-
releases them, then this is all moot anyway, because cat can't go back in the bag. So if you're gonna,
That's a very legitimate
If- well,
consideration.
fine, then,
And that's the twilight zone that we're
If-
talking about.
but
Okay.
it's, we didn't kick this. We did work through it, and we did agree on how not be in the conflict with Prop A,
And that's why I thank you for doing exactly that.
and we did.
And all I'm trying to do is preserve that. And
You're
let me
not.
mention one other thing. I
No,
understand I haven't satisfied what you're looking for.
But you're not,
Several times you've talked about the legislature piece.
Sure.
We are not proposing in our language, and we are listening if you want to give us some feedback. We're not trying to build a wall against whatever the legislature can otherwise do. We've always been subject to that. We are, you are, your members are, you know, if a new bill goes over there and changes this and the court's ruling is no longer the law, then we're stuck with that. We're not trying to write language that gets around that.
well,
I just want that clear because
Well-
it sounded like you were suggesting that we were trying to keep the legislature from,
no. you're
Changing it,
trying-
we're not.
You're trying to maintain something you bargained for. And now the world changed. We said, okay, fine, we'll live with it. And then we said, yeah, but we want to keep it as our backup. That's exactly what you're saying. If the world doesn't work out up here 3 or 4 years from now, we always have this. This would supersede 143.089G because we bargained over it. And what I'm saying is, let G be whatever it is. A group of people decided they wanted this determined by a court and not at the table, and they won. And we're okay. That's America. But the saying is, the reason you want to keep it is to prevent the union from passing legislation, changing it. You can. Because if you don't keep this, well, Sarah, if you have this in here, this supersedes 143.089G. It does.
It would be a bargain for
And supersedes.
superseding.
So if we
143
pass it at the
exactly, and
legislature-
therefore compliant with Prop A. That's the
No.
only way that we can see that we
No.
can be compliant with Prop A with the
Just-
ruling that's pending.
All right. Thanks for your time.